Stop sharing my. Savas, can you hear me?
Yes, I can hear you.
Okay.
Thank you, Apostolos. I'm Savas Varitiniadis. I'm from GN Solutions. I'm a member of the COASTLINE Consortium. We are a member of the COASTLINE Consortium. I would like all the speakers and all the participants of this webline to thank you for your participation. We have 6 presentations concerning the issue of startups and intellectual property rights. I would like to thank once again our speakers for their participation and their contribution. Each presentation will last 25 minutes. I suggest that we can keep the last 5 minutes for possible questions by our audience. I will notify you when you reach the 20 minutes. We're gonna have 2 short breaks, about 10 minutes each at 12 and 2 o'clock and 3 o'clock. It will be about 10 minutes. Our first speaker is Faye Orfanou. Faye Orfanou is an innovation consultant and technology transfer specialist with 25 years of experience. She's the co-founder of Science to Business organization, which supports the integration and exploitation of science into business activities. Ms. Orfanou will present us the basic concept of intellectual property rights in a more interactive way. Faye, we can start. Thank you very much. The floor is yours. You have about 20-25 minutes.
Hello to you all. So I am going to start, let's say, with the essentials. May I ask practically that I can share because someone else is sharing so that I can share my presentation?
Yes, you can share. I just give you access on sharing.
Okay, so my perspective, although I'm going to talk about, the essentials, so I have to be concise and provide you with a lot of information within short time. But my idea is about showing you the why we talk about intellectual property and the core of it. And of course, I'm going to provide some essential basic information on key intellectual property rights. So I'm trying to share now. Yes, great. Let me just make a small note on my perspective and on why I have been working with intellectual property. Initially, I was a lawyer, for a business lawyer for several years, like for 13 years. Then I was in the Ministry of Education and Research as a special secretary. And after that, I started working with technology transfer. So having the legal background permits me to understand intellectual property as the legislator created it, but working in technology transfer, which is IP in action, helps me understand what the economic value of it is. So primarily, let us remember that we are talking about assets which have a value and, of course, several challenges. I would like to start with some essential, let's say, thoughts, informations, clarifications, some core elements. Let me name them. So first of all, just starting from the very beginning, what we have in the word intellectual property, you see 2 core things. If I might ask you to write in the chat if you want, and so on. So if you were to define intellectual property, which would be the 2 elements that you see in this word? If anyone wants just to note what are the 2 elements within intellectual property that you see, or you may write it in the chat. This is a very simple presentation about the road to property, from human intellect, that it's from the mind, from creations of the mind, to money, let's say, to value. So the intellectual property, which has a very interesting history and how it was created.
Hey, just a moment. Are you starting sharing something?
Yes, haven't
You
I?
were- No, I don't see it. I don't know if any other see it.
Can you
The-
see it?
Oh, I see it.
Okay,
Okay.
let me share
you
it
stop.
again. I was
Maybe-
here.
It was
Okay,
fine.
please reshare. Okay.
I was, this was the initial one. I just
Okay, thank you.
started with the
Maybe it
essential.
was my...
Yes, right.
Okay.
So, so the concept is that somehow, which has a very interesting history, why, but let us see the present time, somehow people realized that what the human mind creates may have financial value, may become property. And how could that be? First of all, people could start making transactions. Oh, you have this idea. Can I buy your idea? How much money do you want? So this could be one way to create property out of one's mind. Oh, you made that drawing. It's very interesting. And I want to use it in the package of all my products. So can I buy it? And the other, of course, it was the law. It was the law back in the 17th, 16th century that decided that we can have property, not only of tangible things like my mouse or my house, but we can have property also, the law decided, we can have property of the creations of the human mind. So have that in mind, however simplistic it might seem to you. We're going to use this thinking later on to understand why we have and why they do all these systems of intellectual property. So let's start. We have the human mind, which creates. We have value property, people making transactions on that, and you have the law, which decided to name creations of the human mind as property, as assets. Okay, I can see. Yes, it's true, Mr. Elias, if I may say your first name.
Yes, I
It
passed the
actually,
bar exam.
by the way, the history is interesting because you had two systems. It was the French who focused on protecting what you created, even as art and literature. And it was the Anglo-Saxons, let's say the British, the English, who decided that sometimes what you create can be used in practice, in the industry, in the factories, and it has an economic value. So it has a very interesting history. Yeah, right, exactly. But let me be practical, more practical now. Enough with the history, but it helped us realize what we're going to talk about. So if I may say some of the elements that you see in all types of intellectual property, well, it's something which is new, novel, unique, and there is some sort of creativity, like let's say if I draw a line with on my paper, might not be that creative. So there is creativity involved, something new, which no one has seen before. And for these reasons, it's something unique that's starting becoming more concrete. But have this in mind: novelty, creativity, then uniqueness. However, too generic. I talk very generic now because intellectual property is not a one-size-fits-all. There are different legal types of rights. There are different types of protection within a legal system, and we'll see that. I mean, there's intellectual property rights, which is created just because you created, like a copyright. I finished my book and I published it, or even I sent it to a friend. I finished my song and I sent it to someone, or I designed something and I send it to someone and she sees it. So I'm protected, but there are other types of creations which starts becoming intellectual property rights once you register them. So we'll see there are different types because we have different creations. I just mentioned before, design and scientists make inventions, quite different. So we have different types of rights, different types of how the right is born, either by creating it and announcing it or by registering it. And there are different types of how we can make money out of them. But the overall idea is novelty, uniqueness, creativity, and the fact that I can make money out of them. So again, have in mind, as I said, that somehow what we have created, people, in order to be able to have an asset, people must know that it exists. It's not just I have something in my mind, or I believe I wrote somewhere a song, but nobody knows about it. So publication at some stage, and we'll see that, is also critical. So an asset, an IP asset is there when other people know about it, whether that is registration or publication is by showing a video on YouTube. Okay, so have that in mind as well. But as I said, there's no IP that's one size fits all. So we may have one product and many intellectual property rights. This is a picture by the EPO, the European Patent Office. So whenever the copyright is of the EPO, you will seeing it. So, okay, we have an iPhone. And first of all, we'll explain what that is, but I'm just mentioning rights. It has trademarks. I mean, the name Nokia and the name product 208 or the tone, they have been registered as elements of the identity of the phone. So trademarks. So a right might be on the identity, the logo or the name. That's something that is protected, trademarks. But also, the people who worked to create that, actually several people created several creations, which are all combined in that. And it was, of course, the software and the ringtones and the startup tone and a lot of images, and there, even the user manuals. So people created music code designs. They didn't register that anywhere, but they created that. It became public, so they have copyright on that, and we'll see. But there has been some inventive work. I mean, really disruptive, going forward with what technology knew at the time. So some people created novel technology and they registered that as patents or utility models. We'll see the difference. Patents, which is very inventive. Utility model is something more technical and three-dimensional. We'll see that. And not only that, we have designs, which were registered as designs, the whole form, the arrangement of the pictures, how they are. And also, apart from all that, some of the copyright, some of the concepts or the methods, well, not only are original, like the copyright, but they are kept secret, so but nobody knows it. So they also, apart from being a copyright, they become trade secrets. So you may have one product and it may have a lot of IP rights. So you have something in your hand, which is like a treasury with a lot of assets on it, which are all valuated. They have a value. Each right has a distinct value, and they all add up to the value of your product. Something which is critical to understand. We are here among us, there are people from different countries. And we're talking we all understand what intellectual property is. But if we see it under a legal point of view, but also under a practical point of view, it's very, very critical to understand that it's not the same in all countries. There are some common rules, like similar, I would say there are similar legal systems, but each country, each jurisdiction, as we call it in the legal language, has a different legal system, and there are even differences. Like, for instance, before I mentioned utility model. This does not exist in Anglo-Saxon country systems like the UK, Australia, Canada, the US. The only thing they know is patent, which is a wider thing. Well, you go to, as we call them, continental legal systems like Germany, France, Italy, Spain, various Latin American countries which have adopted this also continental, as they used to call them, systems. So they have utility model. So there are different legal systems, but not only that. Because an IP right is created within a country, within a jurisdiction, under its laws, initially, what the IP does, which is saying you are unique, you are exclusive, you have created, you are the only one who did that, is initially within the country under which it becomes a utility model. We'll understand that later, but have in mind that geography matters a lot. So let's start explaining the different rights as far as possible, because it's, as I said, the essentials. First of all, so see that we have like 6 types, and okay. These words are again from the EPO teaching kit. I chose to use that, but I'll explain a little bit more apart from what you see here. So the people talk a lot about patents, and they also do that because, as I said, which is very critical to understand, because under the American ecosystem, which is the most known, patents and utility models are the same. And also sometimes a lot of things that cannot be patented in other countries, also like copyright, is also patent in the US. So people keep talking about patents, but the legal reality in most systems is that patent is the exception. It's an exception that you have made an invention. Patent is about invention, and invention means creating something which is not only new, like let's say I'm putting the cap of my pen like this, or like I put a little ribbon in it. That's okay, that's new. Nobody has put a ribbon on it, and it's original maybe. But it's not inventive. Inventive is when you disrupt science or technology. You do something which is not at all obvious, even to the scientists, which advances science or technology a step forward. And so it's very important that you have an invention, and this invention is applied in the economy. It says in the law, industrial application. It's not like I made, you may have, I mean, like, people who work in nuclear, in, let's say, in physics, in basic physics, they may discover or even create new methods, but maybe they have no application in the economy. So patents are about inventions. And you don't have a patent once you finish the invention. In order to get a patent, you have to describe what you created to prove that you are unique. First of all, that you are the first one who did that novel, that it is novel and that it advances science, that it's not obvious, that it's been secret so far. So you were the first, and nobody else has published that, even not you. And after an examination, which takes time and a lot of money, by the way, you get it registered. So you have a patent about your invention. When you are, as I said, in the UK, the US, Canada, Australia, even if you don't have a scientific invention, but you have a practical new three-dimensional solution, like the new door of a refrigerator, let's say, opens when at first the refrigerator opened with two doors, or if you have a new handle, if you create all of these gadgets that we see in Indiegogo or in crowdfunding platforms or in Instagram, a lot of gadgets, all these new technical solutions, which are three-dimensionals, not only methods as in patents, but three-dimensionals, then you can have, then again in the UK, US, Australia, Canada, you may also have a patent. But if you are in France, Germany, Italy, Spain, Latin America, also I think the way it is India and Japan, I'm not sure about Japan, the way they perceive utility model, but I'm sure about Latin American countries. You have a utility model, which is different, right? With different protection and the different description. But then again, you have to apply, describe, get examined, and register. Well, so let's go to another type of right. Copyright, that has the French history behind it. So copyright, which in Greek we say πνευματική ιδιοκτησία, for those of you who are Greek, while intellectual property is διανοητική ιδιοκτησία, the wider umbrella. So copyright is the right that the law transfers upon you once you have created something, period. You don't register it anywhere. You don't have to get examined on it. As long as a creation of your mind, whether it's a scientific method, whether it's a practical method, where there is something you draw it, a design, whether it's code and algorithms, whether it's a poem or a song, anything that your human mind has created, which is original, which means you're the first that did it, creative, like we said, like putting a ribbon here is not that creative. So original, which is the new to all people, and creative. And of course, as long as you can prove that you were the one who did it, which means that there's a timestamp. I was the first one, it's original, so it exists. You have a right. And if someone tries to say that it's mine, you can prove, no, it's mine, and I have the right to stop you from doing anything and using it, my idea. We'll see the practical side of it, but I just wanted you to see that there are several rights. Sorry, I have to stop this thing again. As I said before, also there's a right on parts of your on names or pictures that distinguish your products, your creations, actually your products, because it's only on commercial products and services. So you have also a right, which again you register. You can also design, register designs and have a right on something, on the appearance of something, which is distinct and original. And as we said before, you have a right, which is not exactly intellectual property as such. Once you have created something like a copyright or some information, which is not a creation, once you keep it secret, it also has similar legal protection as the other, and even more, because also confidentiality of that creation is critical. So you've already seen that there's so much, but let's again and go to the generic picture to remind us of the critical of what happens. First of all, I'm gonna come back to that later. There is a complicated issue with these rights because it's property rights, and property means the one who owns something has money. Keep in mind that in some of these rights, the creator may be another person and the owner may be the company where the creator works. Like, I work in a chemical industry, I'm a scientist, I make inventions. Of course, I'm the inventor, but the patent is paid and registered by my company. I'm a university professor, I make an invention, but like all over the world, in Greece, it's a very different system, unfortunately or fortunately, which combines everything. But if you're, let's say, in In Germany, and you're a university professor, you are the inventor, but the patent is registered by your university, unless, of course, there's a different agreement, but that's the principle. So you see, and sometimes, even in copyright, the law says you are the owner if you have created something, but you can transfer the exploitation right, the economic right, the economic side of the right to a company. Like, for instance, if you write verses on a song, you may transfer the right, or if let's say you're a painter, you may transfer the right for the exploitation of your paintings to a gallery. So have that in mind. It's very important, because especially with copyright, it might be the members of a startup who have created something, but they have to transfer the right to the startup. And also, you might be sciencepreneurs, which means a startup which is created by scientists in order to exploit a science-based product. So the patent, the inventors may be members of the startup, but the patent may be registered in the name of the startup. So that's a critical thing to have in mind. And of course, there are a lot of IP relationships. I'm looking at time, so I go forward. So have in mind that there are people involved in it, right? I'm not. Have also in mind, before I go and explain to you the value, the protection, all this, why the hell do we have an IP right? But keep in mind that in the IP world, you very often can get lost in translation. There are very blurry areas. Like before, what is utility model and why something which the Americans call a patent is not a patent in Germany? And there's a confusing terminology. I mean, why? I mean, I'm the creator and I'm not the owner. And also there are different meanings, like intellectual property, when you see it in a contract written by an English lawyer, is a wider terminology than when you talk about IP in a Greek, for instance, contract, which is much more concrete. So there are a lot of mistakes. A huge mistake is about trade secrets, is about what we perceive as copyright. There are people who even say that your know-how, I mean, the knowledge that you have in your head is intellectual property, and you have a right on it. Like you transfer your head. And there are people who, so there is a lot of blurriness. And what you should have in mind, that please have in mind to ask an expert or even two experts to be true, whether they work with intellectual property a lot, whether in the financial or the legal side, and to understand, because this might cost you money if you don't understand what you transfer, if you don't have clear rights and you want to get funding. So this blurriness, I mean, you need a compass in this world. So let's be practical again. So why do we say that it is an asset? I mean, all we've said now is about several types of something which we will call property, and so complicated. But why do we do that? So yes, it's money. And why? First of all, the most innocent thing to think is that everything that we create has a moral value. I mean, it's valuable for us, isn't it? We've made some, we invested time and intellectual, let's say, effort. So it has a moral value. And actually, to be honest, even the law acknowledges that yeah, you will always have the moral right, which means that nobody can, that if anyone doubts that you were the creator of something, you can go to court and ask them to stop saying that. I mean, nobody can doubt that something is yours, that you created, because you have the moral rights. I mean, your feeling that it's mine, I created, is also protected, but can you make money out of that? No. So it has an economic value, but why? I mean, and how? Well, first of all, because if you register something, or if you publish your creation in copyright, or if you notify your creation but keep it secret, like a copyright under trade secrets, this you get something in your hands, an acknowledgement that you have created something which is unique. And the law, the fact that you call it an intellectual property, acknowledges that you are exclusive. So you are entitled to demand, to ask anyone that you are the only one who can make money out of it. And whoever wants to even use it to create something like a next step has to ask you for a permission, a license, and even has to pay you for that. Scientists actually, who the one builds on the intellectual property of the other, they don't ask for money because that's how science works and research. But out there in business life, if someone wants to work on what you have created, even use it, not use it with a bad purpose, like saying it was mine, but just use it to build upon it, they have to ask you for the freedom to operate, for a license to get the freedom to operate and even paying you. Not only that, so you have something which for which people can use only if they ask you to and pay you for that. That's something. They need you and they pay you for that because you're the only one who created that, whether that's even for your trademark. I mean, people can pay you to use this fantastic name that you used and they want to use it like part of their own trademark. They have to pay you for that. And not only that, if anyone even doubts that it's yours, if they start using it without your permission, if they even start mocking it, like particularly in designs or even in utility models where they make something which is, let's say, strange, and they sort of undermine the value of what you have created, you can ask for damages, you can ask for compensation, so you can again make money out of it.
Hey, your time is about to end, so you have 3 minutes, so you can.
Yes, I know. What I want to, I have my clock ticking, but I have to explain. So this is something I'm gonna send you. Sorry. Let me go here because I have all my presentation. There are two things I also want to show you. I guess it was clear why we have something valuable. But let us see them in action. A patent document, as you see, is a registration that you are unique, and it has all the critical information which show what nobody else can do unless they ask you for a license. So the description is something that delineates, that sets the limits of what you have created. When you have copyright, when you don't register anywhere, it's good that it is important that you have at least described it in any document, even if it's not registered in a registry. This is exactly, something that you have to have in mind again, is that we can patent products which are three-dimensional, but we can patent also processes and methods and even chemical substances. Sorry, I have my... And so, utility models, as I said, is something three-dimensional. Again, you describe how it is done. And what I wanted to show you, finally, there are also plant variety, which is another right. Let me also show you something about copyright. Copyright is very important, which is not registered. It is very important that it is documented. So again, you can describe what exactly is this original and novel thing that you have created. You document it. If you want to keep it a trade secret, you just show it to someone under a non-disclosure agreement. But if it doesn't really matter economically for you to keep it a secret, you can publish it. Let me stop because it makes you dizzy. I want to find the right slide for my final, because I use this presentation and I intended to send it to you so that you can use it with all the information that I was not able to say. But I think that what is I'll show this. What I think is very important for you is, I found it, great, is to have an IP strategy. Sorry, I guess you can see it now. All right. So as you saw, sorry, I don't know why this happened. I found the right slide, but sort of, okay. As you saw before, their IP is complicated. It is blurry. You need someone that gets to consult, that provides you with advice. In order to ensure that you have exclusivity, you have to test out that you have to ensure that nobody else has it. So you have to compare with similar creations. And also, you have to evaluate how much value this has, because we're saying it has value, but financially, how much value does it have? So it is very, very, very important to set up an IP strategy. You cannot, any of the things I said, which again was generic and concise and just gave you an idea, might not offer you anything, even if you know it by heart, even if you know all the details, unless you treat intellectual property under a strategic approach. So it's very important that you set an IP strategy from the very beginning, where you identify all the unique elements, then find which type of IP is there. Also, you take your measures how to maintain their uniqueness. So when somebody copies you, or also when someone wants to make use of what you have created, whether it's a patent or copyright, you ensure that you don't get copied without knowing, that you stop them from that. You have a strategy of protection, especially when you create it and you wanted to keep it secret, or when it's a trade secret, and you have the experts that you ask. So it's important that you dedicate like a week of your, let's say several days, to ask to work on your IP, identify your IP items, document them like I showed before, because everything is fantastic as I describe it, but all the dangers are in the description. What exactly have you created? What exactly have you invented? And then how do you protect it? So with that, and because you have to take measures, have in mind, just like I'm leaving you with this picture, it's important to, as you saw, there's a lot of information involved and different types and different systems, but the key element is that you approach IP with under a strategic mindset, to identify all the critical IP items, ask the expert, set up your protection policy, so to ensure their value, and to ensure the value and be able to exploit them. I hope this was useful. It was so much to say, so.
Yes. Thank you very much, Faye. Your speech was very valuable, and all the